Honorable members, thank you. Please be seated. And we will resume consideration of the Constitutional Reform Commission bill. And the next speaker is the Honorable Minister of the Public Service. Public Service, the Honorable Member, Ms. Sonia Purak.
Good afternoon, Mr. Speaker
Good afternoon.
and members, honorable members of the House. I'm standing before you to support fully the bill for the Constitutional or the Constitution Reform Commission. The Constitution of Guyana is the embodiment of fundamental principles and rights and freedom of all Guyanese. And as society moves forward, progresses, evolves, or a country evolves, so must its constitution and the rights and freedoms that lies therein. As a consequence, this particular bill, all bills that are brought by this government to this honorable house are people-centered and targets specific categories of persons at different times. This specific bill encompasses or captures all of Guyana, all citizens. And not only does it do that, but in comparison to what would have obtained during 2015, or as the Honorable Attorney General said, 2011 to 2020, this particular bill seeks to be inclusive, a hallmark of the PPPC government. It seeks to mandate consultation with the public, and I think that we need to emphasize and re-emphasize that point, because we can't amend a constitution or establish a commission with the aim of amending a constitution or reform a constitution without the input, the necessary input of the people. And so widespread consultation, I would say, is the most important part of this particular bill and the establishment of this commission. The fact that the commission has just about 20 persons coming from all sectors of the country says quite a lot in terms of what we want to achieve. And so today, Mr. Speaker, because the speakers before me would have said much about the bill, as a matter of fact, all that can possibly be said about the bill. But I fully support the bill that is brought here, and I do believe that the aim is, as always, to include the people of Guyana. Thank you very much.
Thank you very much, Honorable Minister Parag. And now, the Honorable Attorney General and Minister of Legal Affairs.
Thank you, Mr. Speaker. I want to thank the members who spoke in solid support of this bill. I want to also assure my colleague on the other side, the Honorable Lennox Schumann, that I hear his call, and I want to assure him that our government historically, currently, and futuristically stand committed to the advancement of the welfare of our Amerindian brothers and sisters. I want to also remind him that it is under our government that a Ministry of Amerindian Affairs was established and a minister appointed to administer the affairs of that ministry. It was under our government also, and through a previous constitutional reform process, that the Constitutional Commission of the Indigenous People was established. And again, in keeping with the high priority accorded to our Amerindian brothers and sisters, in 1996, we enacted our Amerindians Act, and enshrined in that act 2006, and we enshrined in that act the concept of internal self-government for the Amerindian community in our country, the only ethnic group that has been visited with that right of internal self-government. Mr. Speaker, this bill again demonstrates and illustrates the priority which our government accords to our Amerindian brothers and sisters by recognizing and making a place as the only ethnic group with a presence and a representation specifically ethnic on this commission. We chose the National Tushao Council in our legal architecture that represents the widest cross-sections of Amerindian people across the length and breadth of our country. Should we move into the direction of having a second representative, and we don't wish to do that. As I said, the Amerindian community of our country has a special and specific. Of course, those of them who fall into the private sector will have private sector representation. So will represent the Amerindian community without doubt. The religious organizations will represent. The Amerindian is part of the religious architecture of our country. So, Mr. Schuman, Honorable Member, please be assured that the Amerindian welfare is recognized, I dare say, adequately. Mr. Speaker, I want to thank in particular our senior colleague, Comrade Gail Teixeira, who took the opportunity to remind us of the travails that we have endured and encountered in this country as we attempted to reform our constitution at various intervals. I wish to just add that there was another process which Comrade Teixeira did not mention, and it had to do with the reform of the 1966 Constitution in 1970. It's important that we put these things on the record so that we can, young people and our population generally can understand what inspired constitutional change when our government was in office and what inspired constitutional change when our government is out of office. We already spoke about the diabolical process which produced the authoritarian 1980 Constitution. But there was a precursor. After the 1968 elections was massively rigged, in 1970, there was another constitutional reform process. The PNC then, having rigged that election sufficiently to empower themselves to change the Constitution at the time. Of course, laudable precepts and concepts were advanced as the basis for the change. It was to move us into Republican status and to remove all links, or what was described then as the last vestige of colonialism, and for us to have as head of state no longer the Queen, but a president, at that time a titular president. But hidden among those reforms, Mr. Speaker, was that reform that abolished the Privy Council from our legal system. And it is the abolition of that important adjudicatory body at the apex of our judicial structure that sowed the seeds for the authoritarianism to not only be ensconced, but to be immune from judicial challenge external from Guyana. So we must not omit these important things and must always put them on the record. And that is what happened under the PNC. Fast forward to 1999-2000, Comrade Gail Teixeira spoke about the impenetrable and vast amount of power which was vested in the 1980 Constitution. The 1999-2001 Constitution effected over 200 changes in dismantling largely that heavy monolithic concentration of power in the executive and to divert it importantly to the opposition and the National Assembly. And if one examines the philosophy and the undercurrent that underpinned those constitutional changes, you will see the migration of power away from executive poles to the peripheral organs in the constitutional structure. So there was, President used to appoint Chancellor and Chief Justice over a rubber stamp process of consultation. That was changed to have agreement. It has not worked, and perhaps we have to relook at it. But it demonstrates the type of commitment. The whole establishment of these constitutional commissions, empowering Parliament in the process to constitute these commissions. Not only their establishment is something that we should laud, but the process to constitute them came from a bipartisan process put in the bosom of this National Assembly. The powers of the President in terms of immunity was substantially reduced. The power to remove a government by way of a no confidence motion was for the first time put in the Guyana Constitution. The establishment, Mr. Speaker, of a provision that allowed for us to adopt the CCJ when it came on board without a constitutional amendment, was the germ of it was put in the Constitution itself. So when the CCJ came on board, we didn't have to amend the Constitution. And we all have lived to witness the benefits that Guyana has derived from an external apex court in our judicial hierarchical structure. And Mr. Speaker, I can go on to highlight the amount of good, benevolent, democratic changes that 1999 to 2001 process brought to the House. The establishment of the standing committees and making them part of the constitutional architecture of this National Assembly and ensuring that they represent sectoral interests across the length and breadth of human endeavor in this country is again a check and balance of power given to this Parliament to oversight executive functions of government. So, Mr. Speaker, the Guyanese public should never be in doubt, and the record of this country must always reflect that when the PPP is engaged in constitutional change and in an effort to bring about constitutional change, there is one pole star by which we are guided, and that is the best interest of our people, the advancement of our legal system, and the enshrinement of democratic norms and tradition. Mr. Speaker, I am proud to say that this bill does exactly that. and lays the foundation for us to take constitutional reform to the next level as we continue to build our country for the next generation. I thank you very much, Mr. Speaker.
Thank you very much, Honorable Attorney General. Honorable members, there being no other contributor, I now put the question that the bill be read a second time. Those in favor say aye. Those against say no. Ayes have it. Let the bill be read a second time.
Constitutional Reform Commission Bill 2022, Bill number 18 of 2022.
Honorable members, the House will resolve itself into committee to consider the bill clause by clause. Honorable members, there are 17 clauses in the Constitution Reform Commission Bill 2022, Bill number 18 of 2022. I see that there are no amendments, so I will propose the question that clauses 1 to 17 now stand part of the bill. I now put the question that clauses 1 to 17 stands part of the bill. Those in favor say aye. Those against say no. Ayes have it. Clauses 1 to 17 now stand part of the bill. Honorable members, I now put the question that the bill be reported to the National Assembly. Those in favor say aye. Those against say no. Ayes have it. Let the Assembly resume. Honorable Attorney General and Minister of Legal Affairs.
Mr. Speaker, I rise to report that the Constitution Reform Commission Bill 2022, Bill number 18 of 2022, and was passed without amendments. I therefore move, Mr. Speaker, that the bill be as printed.
Thank you. The question put is that the Constitution Reform Commission Bill be read as printed, be read a third time. Those in favor say no. Ayes have it. Let the bill be read a third time.
Constitution Reform Commission Bill 2022, Bill number 18 of 2022.
Honorable members, we will now proceed with the second reading of the Motor Vehicles and Road Traffic Amendment Bill 2022, Bill number 19 of 2022, published on the 29th of July 20. Mahabir Anil Nandla.
Thank you very much, Mr. Speaker. Mr. Speaker, this is yet another very important piece of lawmaking critical to the public safety of the people of our country. Mr. Speaker, an important component of lawmaking is to address societal and our social ills which are symptomatic which the law is to operate. Mr. Speaker, road traffic accidents, the carnage which takes place on our roadways, and the must concern every single Guyanese. In a population of less than 1 million people, our per capita deaths on the road is perhaps one of the highest in this hemisphere. I have in my hand here statistics obtained from the Road Traffic Department of the Guyana Police Force. And the data, Mr. Speaker, expectedly is staggering. Over the past 10 years, from 2012 to 2022, 1,303 persons were killed on our roadways. Mr. Speaker, that is over 100 persons per year. Out of that, 1,072 were males, 231 females, 89 were children. No political party, no civil society organization, or no sensible citizen of this country can find comfort with these statistics. I have chosen only the last decade as part of my presentation. But like everyone in this house and who are listening would know, the last 10 years statistics is consistent with statistics going back decades. So we have had on our roadways human plundering. Genocide may be a heavy word. And we simply cannot continue as a responsible society and as a responsible government. Continue to ignore this horrendous loss of life. Mr. Speaker, any examination of the data will also establish, and everyone listening to me can relate, that there is a deep causal connection between these road accidents and fatalities and alcohol or drunken driving. We live in this country, and I don't think I need to plead a case of a connection between drunken driving and the resultant road accidents and fatalities. Every month, our newspaper front page, at least once every month, is unfortunately punctuated with some scene of some horrific road traffic accident. And when one reads the story, Mr. Speaker, when this bill was being drafted, great care was extended into ensuring that while it addresses the situation, that also that it's formulated in a manner that will ensure compliance. This bill and the one that succeeds it, the Intoxicating Liquor Amendment Bill, both introduce concepts that are both new and novel in our law. And there will be great difficulty, no doubt, first of all, in getting our citizenry to become familiar with them so that they can comply with them. But even more importantly, there is violation, because that is also going to be a challenging issue. Mr. Speaker, these bills were drafted months ago. They were posted on the Ministry of Legal Affairs website. A public advertisement was placed in all the media outlets, or the major media outlets, drawing attention to the publication of these bills on that website and inviting comments, submissions, and views. His Excellency the these bills on his Facebook page, and I did so, and I believe some of my colleagues may have followed suit. Mr. Speaker, at the time, I examined the response, both on His Excellency's Facebook page and on my Facebook, that the response was overwhelming in support. Additionally, we got inputs from members of the public, but not one of them was critical. We received full endorsement from the Guyana Road Safety Council. So, Mr. Speaker, I am confident it has received national approbation and obviously is a timely lawmaking intervention. Mr. Speaker, the World Health Organization in their report A Road Safety Manual for Decision Makers and Practitioners 2022 says this: on the brain can be depressing or stimulating in nature, depending on the quantity consumed, which causes degradation of driving performance directly related to blood alcohol content levels. Alcohol results in impairment, which increases the likelihood of a crash because it produces poor judgment, increased reaction time, lower vigilance, acuity. Psychologically, alcohol also lowers blood pressure and depresses consciousness and respiration, unquote. Mr. Speaker, This is the World Health Organization. The world on the impact of respect of driving. Again, I go to the World Health Organization Global Status Report on Road Safety for the year 2018. And I quote, driving after drinking alcohol significantly increases the risk of a crash and severity of that crash. Unquote. In fact, it is a fact that persons continue to drive after drinking because they do not think that drinking impairs their ability to drive and to do so in a careful manner. However, the reality of the headlines we see in daily print paints a radically different picture. Even in cases where alcohol is consumed in small quantities, its very presence in the human system diminishes vision and reflexes and impairs judgment. Mr. Speaker, against that backdrop, our government felt or feels compelled to make this intervention, and I will concede that it is one that may be described as drastic, but it is done simply to save the lives of the citizens of our country. We are dealing with a chronic problem and a problem, I dare say, of an extraordinary nature. And Mr. Speaker, the response legislatively must be commensurate with the gravity of the harm or the gravity of the problem that we are dealing with. Mr. Speaker, again, I refer to the United Nations. At the level of the United Nations, the Sustainable Development Agenda of 2030 recognizes the importance of road safety through Sustainable Development Goal 11.2, which calls on UN member states improve road safety. Additionally, in 2020, the UN adopted the UN Resolution 74 of 299, which declared the period 2021 to 2030 as the second decade of action for road safety. Mr. Speaker, Guyana to this UN delegation, UN resolution, and UN commitment to the world. Mr. Speaker, the Motor Vehicle and Road Traffic Act, Chapter 51, colon 02, is the primary piece of legislation governing road traffic, the use of the public roadways of our country by vehicles and by other road users, and also the licensing regulation in respect thereto. The purpose of this bill, Mr. Speaker, is to amend that principal act in three major ways. Firstly, to provide for new offenses of motor manslaughter and grievous bodily harm while driving under the influence of alcohol or a drug. Secondly, dissuasive penalties, imprisonment, harsher fines, from holding or obtaining a driver's license for the offenses of causing death by reckless or dangerous driving and driving under the influence of drinks or drugs. And thirdly, Mr. Speaker, these amendments provide for consequential amendments to procedural provisions of the Act dealing with the testing of breath and blood of the accused or suspected person for the aforementioned offenses. So, Mr. Speaker, those are the broad objectives which this bill seeks to achieve. And I will try to go through the clauses in the order in which they appear in the bill, and not necessarily in order of importance. So clause 2 of the bill, Mr. Speaker, amends section 35(3) of the Act, which provides for the offense of causing death by reckless or dangerous driving. Now, as the section says, the offense is called causing death by dangerous or reckless driving. So in order to prove such an offense, the prosecution has to establish that there was dangerous driving or reckless driving, and that dangerous driving or reckless driving is what caused the death of the deceased. So if the deceased died of another cause, for example, he was in an accident, but on his way from the scene of the accident to the hit him and he dies from that, then this driver can't be charged, can't be convicted for that offense, because there is what is called a novus interveniens. There was an intervening factor. Now, under the current law, the case is tried before a judge and a jury, then the jury is free to convict, not on the ground of causing death by dangerous driving, but for the lesser offense of dangerous driving or reckless driving, as the case may be. As a judge and jury, which is if one of these cases reach the High Court for determination, because a judge and jury only sits in the High Court. The practical reality, however, is that most of these cases are determined in the magistrates' courts of our country. What this amendment seeks to do is to simply empower the magistrate to do exactly what the jury could have done. So now, if the magistrate is trying the matter and the prosecution is unable to prove that the causing death or the death was caused by reckless or dangerous driving, then they can convict for the lesser count or the lesser charge of careless driving under section 37 of the Act. So that is clause 2. Clause 3 is where that one was more of a procedural nature to bring the principal legislation in keeping with the realistic changes that have taken place and determined in the magistracy. Clause 3 of the bill introduces for the first time the offense to which I've made mention. It seeks to amend the Act by inserting a new section 35A to provide for the offense of motor manslaughter and causing grievous bodily harm when driving a motor vehicle under the influence of drink or drug. Motor manslaughter is a completely new concept in our jurisprudence, though it exists in North America. A person who causes the death of another person while driving a motor vehicle under the influence of a drink or drug shall be guilty of motor manslaughter. This is an indictable offense which carries a penalty of a term of imprisonment not less than 10 years. Not less than 10 years. And that is the seriousness that the legislation views when death results because of drunken driving. And I can't imagine anyone would have a difficulty with this. In the year 2022, no one should want anyone, be it their friends, enemy, or family, to be driving in a state where they cannot exercise due care and control over a motor vehicle. The motor vehicle becomes a lethal weapon, not only against the driver and the occupants of that particular motor vehicle, but it becomes a lethal weapon against all road users, including any one of us here. Bodily harm is where the person who causes grievous bodily harm to another was driving under the influence of drink or drug. So death here doesn't result, but grievous bodily, and the penalty is a term of imprisonment of not less than 5 years. So this is where the injury is grievous, serious, of a grave nature. The penalty is not less than 5 years. These are all minimum penalties. A magistrate has the statutory freedom of going much higher if the facts and circumstances of the case warrant a higher sentence. This new section also provides the magistrate with the power to do exactly what a judge and jury could have done, as I explained before in relation to the previous section. So I don't need to take you through there. But an important part of the penalty is disqualification from holding or obtaining a license. And please listen carefully. A person convicted under this new section shall be disqualified from holding or obtaining a license for 3 years. So a person who is convicted either of motor manslaughter or of causing grievous bodily harm under this section shall be disqualified. So there's no power here, there's no discretion here. Disqualification is part of the sentence from holding or obtaining a license for a period of 3 years. In the event that the person is convicted again for a like offense, the person shall be permanently disqualified from holding or obtaining a license. Now, I know that these are serious consequences. They were examined, analyzed when we were drafting. I am not unaware that that a driver license is an instrument that people use to earn. I am not unmindful of that. We are not unmindful of that. Taxi drivers, minibus operators, truck drivers. I know the economic connection between the driver license and livelihood. But if you want to use that license, nobody telling you don't drive. This offense will not apply if you are sober. This section has no application if you are sober. So if you are sober and you make an accident, these harsh penalties do not apply to you. And I want to make that very clear. It is when you are drunk and you have no right to drive in that intoxicated level. Mr. Speaker, Clause 4 seeks to amend the Act by inserting a new Section 38A in the Act to provide for temporary suspension of a license pending the determination of a charge in circumstances where a person is charged for a second or third time with the following offenses. Before I get there, let me emphasize what this means. We were speaking about conviction just now and disqualification post-conviction. Now we are introducing a different regime, which is suspension ante or before conviction. Now this also was not lightly done. We had to look at the presumption of innocence, a constitutional protection, and the imposition or the apparent imposition of a penalty prior to a finding of guilt by a court of competent jurisdiction. All those legal issues had to have been interrogated and satisfactorily resolved before we could have ended at this result. And you will note that it does not apply to a first charge. But if you are charged a second or third time with offenses under 35A, that is the motor manslaughter offense and the causing of grievous bodily harm offense while driving under alcohol or drugs, or you are charged with a section 39, which is driving under the influence of alcohol or drug, whether you make an accident or not, or section 39A, where you're driving or being in charge of a vehicle while your breath or blood level exceed the prescribed limit. Now there's a difference in these two categorizations. There is a prescribed limit category where you can be charged as a lesser of the offenses. When they say driving under the influence or drink or drug, they are speaking, and the section explains it in the Act. If you look at the Act, in the bill, you must be in a state of or condition where you cannot maneuver or control a vehicle, which is a different level of drunkenness. So there is a strata of consumption and outward behavioral pattern in relation to these offenses. Where a person is charged a second time with the aforementioned offenses, the court may order suspension of the license of that person pending the charge. And upon suspension, the license of the person shall be surrendered as soon as practicable to the court before which the person is appeared. So when there is a second charge, the court may order suspension. So I spoke about a graduated approach. This is where there is a second charge, the suspension is may. So the magistrate may or may not. However, if there is a third charge, where the person is charged a third time for the same offense, well, then the court shall order suspension pending the determination of the charge. That must be considered fair because the law is giving several opportunities for reform and rehabilitation to take place. Why should anyone be charged 3 times for the same offense? It means that there is a problem. There is a problem. And failure to surrender the license is also an offense. Clause 5 seeks to amend Section 39 of the Act, which provides for the offense of driving a motor vehicle under the influence of drink or drug to such an extent as to be incapable of having proper control of the vehicle. So this here is the offense that I'm speaking about, and is when you are in this state and you cause death or you cause bodily harm, those offenses are activated. Here, if you are caught in this condition, but you have not caused an accident, obviously, you have committed an offense. And that is already in the law. What we are doing now is to increase the penalty. Subsection 1 is amended by increasing the monetary penalties for the offense. Currently, the penalty is a fine ranging from 30,000 to 60,000 or imprisonment for 12 months, and in the case of a second or subsequent conviction, to a fine ranging from 40,000 to 80,000 and imprisonment. The monetary penalties are amended to reflect for the first conviction a fine of not less than 200,000, and for a second or subsequent conviction a fine of not less than 300,000. If you don't drink and drive, you are not affected in any manner whatsoever by this regime of changes in the law. Additionally, subsection 2 of this section is amended to provide that a person convicted under this section shall be disqualified from holding or obtaining a license for 12 months minimum. So, if you are convicted of this type of offense, where you are found driving a car where of having proper control of that vehicle, which is a Section 39 offense, then upon conviction, you shall be disqualified from holding or obtaining a license for 12 months. And again, I remind rather, that this is a minimum sanction. The magistrate is free to go higher. Where the person is convicted for 2 consecutive such offenses, the person shall be disqualified from holding or obtaining a license for 24 months. So if you're a second offender, convicted a second time for the same drunken driving, well then you have a 24-month suspension. If there is a third conviction, then you have permanent disqualification from holding or obtaining a license. Mr. Speaker, Clause 6 seeks to amend Section 39A of the Act, which provides for the offense of driving or attempting to drive or being in charge of a motor vehicle on the road or other public place while the breath or blood alcohol level exceeds that prescribed limits. And this is the third of the category of offenses which we are amending. Here we are amending the fine. Subsection 2 is amended by increasing the penalty for the offense from a fine of 75,000 to a fine of 200,000. So the breathalyzer offense, it's now moving from 75,000 to 200,000. Subsection 3 of this section is also amended to increase the period of disqualification of holding or obtaining a license where a person is charged with 2 consecutive offenses from 12 to 24 months. So right now there is a power to suspend after conviction, and we are now adding for a second conviction of 2 consecutive offenses, 2 other convictions, you're moving to 24 months in terms of suspension. Earlier of the procedural amendments, and they are contained, Mr. Speaker, in clause 7 of the bill. Mr. Speaker, under there is a constable who is authorized to carry out this. Based upon our experience, and I'm sure Minister Ben will substantiate it with possibly data, the problem that we have had in securing convictions for these offenses, there's this machine that is being used to test breath, and the machine apparently is not properly calibrated, and the readings consequently are defective or have been found by our court system to be defective off from these offenses. That is being addressed now, and Mr. Speaker, the constable, before they administer this test, must ensure that this instrument that will be used, it must ensure that it is in satisfactory condition and properly calibrated so that it produces an accurate breath result. Mr. Speaker, they certify the instrument for the purpose of evidence. Right now, the sample is what alone is certified. And sometimes you have difficulty in establishing a chain of connection, whether this is the instrument that was used at the scene of the accident, because the instrument is not certified with any stamp or mark. The constable now must certify that instrument so that when the instrument, if the instrument is to be examined by a court, there must be a causal connection. The exercise. Mr. Speaker, 39 of D of the Act, which empowers a constable to require a person under investigation, that is drinking or driving under the influence of drink or drug, to provide a specimen of blood for a test if that person can't give a breath test. Now, there's a serious problem in the current construct of the law. The law in its current construct requires a person to do both a blood and a breath test if one of these offenses are to be proved. To read or. We have made the requirement not an aggregate one, but a disjunctive one. So the constable is free to do a breath. Currently, the law has and or a blood test. The blood test, Mr. Speaker, is a complicated process. You have to get a doctor. It takes a long period of time, and it's an expensive exercise. The instrument that the police has can do the breathalyzer and do the breath test. So we have allowed that breath test. If the circumstance should arise whereby a breath test, for whatever reason, cannot be administered, then and the reading or the millimeter proportion of how it is measured and what is the limit is stated in the legislation, and I don't think it makes. We have now put in our law a regime of changes which we hope will have in the reduction of road accidents and in particular road fatalities right across Guyana. As I said, our government's priority public safety is an important objective and a security priority of our government. In the equation of public safety is safety of our roadways. We must be able to traverse our roadways. Our children must be able to traverse our roadways. Our citizens must be able to traverse our roadways with a sense of security and psychological peace of mind. Drunken driver is not using his vehicle as a lethal weapon along some roadway. Our family, as we seek to do our regular business, we must have a sense of security. Now, as I said, it is going to require changes, and it is going to require a lot of public education. The government's job alone and legislative changes alone can never be able to curb this horrendous, tragic loss of human life in our country. Every member of society, every responsible organization in this country must join as we begin to chart a new course of making our roadways safe.
We're hospitable.